Hello, and welcome to From the Front Row, a program of the Southern Environmental Law Center. The following is from a presentation to our board by Catherine Wanamaker, an attorney playing a central role in our coastal conservation initiative in Georgia.
Thanks, Bill. I want to talk about how we've been working to build a body of law that we can use not only in the cases at hand, but in future cases on the Georgia coast and elsewhere throughout the region. And as I'm sure you've all heard a million times, the Clean Water Act prohibits the dredging and filling of wetlands without a permit. One of the areas of law that we've really been working on over the last several years is some exemptions to that permitting requirement. There are two that I want to talk about today, and the first one is called the silvicultural exemption. And basically what that exemption does is it allows folks who are engaged in the business of normal farming or silviculture, which is tree farming, to do activities in wetlands without having to get a permit for every activity they do on a site. So if you're planting trees or you're harvesting trees on a site as part of an ongoing farming or tree farming operation, you can disturb those wetlands without having to go to the Corps every time you step into one. We have heard from our partner groups and from EPA that the silviculture exemption is really a problem because first there were not a lot of boundaries on it. So what does it cover? Does it mean if you just go out to your farm and you want to cut some trees, is that silviculture? And secondly, because it was being abused for creation of residential development when people said they were actually engaged in silviculture. So we've been working on those issues. The first case that we brought about 2 years ago, I guess, was a case in the Ogeechee watershed down here, and it was a cypress swamp that some lake owners wanted to harvest a bunch of cypress trees from, and they had never done anything to cultivate those trees. They were just naturally there. They'd been there for ages. They didn't have any plans to regrow the trees at all. They just wanted to come in, do a one-time cut, and sell that timber. They went to the Corps of Engineers and they asked the Corps, are we exempt under the silviculture exemption? We think we are. And the Corps said, yes, we agree. You're going to cut some trees, that's fine. That's silviculture. You don't need a permit for any of your activities in wetlands. We view the case as a way to clarify the silviculture exemption because it is supposed to be for regular, ongoing tree farming operations. So we went to court and we challenged the Corps' exemption determination and said, well, that doesn't make sense. That means anytime somebody wants to cut some trees, they're exempt. It doesn't matter if they have a prior operation, and it doesn't matter if they have a future plan, and that's just not good enough. The Corps defended that case. We were down here in front of Judge Edenfield in the federal district court here, and we won. So it was a really good decision for us. He said the silviculture exemption couldn't be clearer. It means past, present, and future silviculture. Here, there's no evidence that occurred in the past, and there's no plan to regenerate the cypress trees, and that doesn't qualify. So that was our first sort of exemption case, and a great victory for us on clarifying the scope of that exemption. Incidentally, just as a point of interest, one of the things that's happening with a lot of the cypress swamps down here is that they're being converted and chopped down for cypress mulch, which people are using in their gardens. And we think it's obviously a big shame that that's happening. They don't regenerate well, we're finding, and we've been working with EPA and are releasing a big study on that this summer at some point, which will hopefully have some impact on stopping that practice. I've also spent some time working down here on marsh hammocks, and not cases brought under the federal Clean Water Act, but just looking for ways to protect marsh hammock development on the coast. As we mentioned earlier, there are over 1,600 marsh hammocks on the Georgia coast, and there's some move to develop some of those. This is one in near Darien in McIntosh County, and it's this little outline here with the trees. It was a piece. It's an 8-acre site, It was zoned for conservation preservation. An individual bought it and had it rezoned for one house. And the next thing we knew, he had gone back to McIntosh County zoning and had it rezoned to put 18 houses out there. This was his plan for the lots. As you can see, they wrap all the way around the border and they sit right on the marsh. As part of that development, he had to apply for a septic tank system permit. So he designed this community septic tank system, which was essentially a large septic tank. There's really no high ground out here, and we had experts look at it and they all said, this will clearly fail. There's no way that it can work. It's just too small, and there are too many houses, and there's too much loading into it. We gave that information to Georgia EPD during the permitting process, but they granted a permit anyway, and we challenged that permit as soon as it came out. And we got as far in the case as filing motions for summary judgment. We were in the state administrative body in Georgia. And just before we finished that briefing, before we got a ruling from the court, EPD called us and said, oh, you know what, we're going to take that permit back. We made a mistake, and we don't think that we should have ever granted a permit for that kind of system in the 100-year floodplain. So that was another good victory for us. Great, thank you.